All right. Good. So we will have a makeup class on next Friday from 2:30 p.m. Okay, thank you very much. All right. So now we start with our lectures. Okay. So I will introduce to you about the general concept of the course. Okay. This course have 2 credit points. Okay, and we will have 30 credit hours, which means we have 40 contact hours. So we have 20 sections altogether. And I just put on the board that we will have 20 lecturing hours and 10 tutorials hours. But in fact, we may have more than that. The actual class time could be 40 hours. So we will have more than that. Okay, so we have plenty of time. And also because our class members, the number of the students is very small, so we have more chance to discuss about every legal issues. You are free to raise any questions you have, and we discuss any issues that you have any concerns. Please feel free to ask the questions. When you have any questions, please feel free to raise your hands, to raise your voice. Do not just keep silence, because if you keep silence, I assume that you understand. So therefore, if you have any questions, if you have any concerns, please raise your voice. Always remember that I'm here for help. If you have any questions, if you have any concerns, please raise your voice. Okay, all right. How about the course objectives? Okay, there are 4 main course objectives that I just want to point it out at the very beginnings of the course, and with the hope that at the end of the course, you will actually achieve at least several objectives. Okay, so the first objective is that I know that you learn English, okay, but actually your focus on legal English. Okay, you focus on legal English. So therefore, this course provides you with the legal terminologies, okay, that help you to understand about the legal terms in the areas of tort law. I know that you are very good at English, okay, but maybe that is a normal daily life language, or it can be academic language, but it's not about legal language. So therefore, the course provides you with a chance, with an opportunities to study legal terms in the areas of the law of tort. Okay. The second objective is that I give you information, it gives you certain knowledge of the law of tort in the United States. Okay. So you know that United States belong to common law countries, okay, and Vietnam belong to civil law countries. Even though nowadays the differences are not many, because the 2 legal systems tend to come very close to each other. People from common law countries go to civil law countries to study many things, including law, and people from civil law countries go to common law countries to study law as well. I take the case of myself as an example. I went to Australia to study law, so therefore I have backgrounds of Australian law, and you know that Australia belongs to common law legal system, so therefore I know some good things, some good points from the legal system in Australia. So I have a chance to understand the Australian legal system, and I will be able to compare and contrast between Australian legal system and Vietnamese legal system, and some areas of Australian legal system as well, because I specialized in commercial law when I studied in Australia. So I have a knowledge of Australian law. So I have a chance to understand it, and I will be able to compare and contrast. Okay. And I also have a chance to participate in several cooperation programs between Vietnamese university and US university, Australian university, Great Britain's universities as well. So therefore, I have a chance to learn common law legal system. And the purpose of learning the other legal system is that to learn good things and also the shortcomings of that legal system, and compare and contrast with our own legal system in order to learn the suitable things. I emphasize that you need to learn some suitable principle, suitable things from other legal system in order to apply in our legal system. You are the next generations in Vietnam, and you will contribute to the developments, to the improvements of our legal system. So therefore, you need to learn other countries' legal system, other country law, with a critical view, critical point views in order to compare and contrast, in order to learn some things with it treated as suitable, okay? In order to improve our legal system. Of course, we can't learn everything from the other legal system, because the legal systems is actually developed based on the level of developments of a particular countries, standards of living, the cultures of particular countries as well. Okay, all right, so that is the second function, okay, which is very important of the course. Okay, the third objectives of the course is that when you study law, you need to study how to apply the law, how to apply the legal rules to the facts, okay? And then you need to learn the law, but the law in book and the law in action, the law in realities could be different from each other, not totally different, but the ways people apply the law, right? The ways people interpret the law. So we need to learn in order to improve our ability to apply the law to the facts. That's why in internal assessment, I will ask you to do the problem solving questions, okay? That is a chance for you to learn how to apply the rules to the facts in order to resolve the case. And also in the final examination, you will be given problem solving questions as well, okay? All right, and and the last but not least objectives of the course is to encourage students to engage in critical thinking of the legal implication. So that is the final purpose, the final arm of the course, that for you to actually to understand, okay, and to criticize, okay, the legal system, okay, outside legal system, foreign legal system, with the views of comparisons, with the views of compare and contrast between other legal system and Vietnamese legal system, and with the critical thinking, okay? So you need to criticize, okay? All right, so they are the core objectives. So before we move on, I just want to ask you whether you know the differences between the two legal systems, common law legal system and civil law legal system. You know that the US belong to common law legal system and Vietnamese legal system belong to the groups of countries that follow civil law system. So anyone know the differences between the two legal systems? Anyone have an answer to that questions? Do you know the differences between common law legal system and legal law and civil law legal system? Okay, so that, do you think that is the main differences between the civil law legal system and common law legal system? Yeah, the main differences between common law legal system and civil law legal system is the sources of law. Yes, you are correct. What else? Okay. So we have a table to compare between common law legal system and civil law legal system. Okay, so you see the green, right? Okay, so the first criterion that I want to make in order to compare and contrast between common law legal system and civil law legal system is the origins or countries of origin. For common law legal system is have an origin from the UK. Okay, and in civil law legal system, the origins of the civil law legal systems come from French. Okay, the second one that your friend Thảo Linh, right? Thảo Linh have the answer to the question, and this is about sources of law. In common law legal system, the main sources of law, or to be exact, the original sources of law in common law countries is case law. Okay, so anyone can give me a synonym of case law? Anyone can give me a synonyms of case law?
The synonym of case law is precedent.
Precedence is actually a doctrine in which how case law is created and developed. So you already talk about the terms precedent, and we have a doctrine of precedent. Anyone know about the doctrine of precedent? How it can be defined, the doctrine of precedent? Okay, I will let you know. The doctrine of precedent requires a lower court must follow decisions of higher court in the same hierarchy if the facts are similar or identical. So that is the doctrine of precedent. The doctrine of precedent requires lower courts to follow decisions of a higher court in the same hierarchy if the facts are similar or identical. Okay? Sorry, I need to close the door because it's types of noisy over here. Okay, can anyone find out the synonym of case law? Case law is actually developed from the doctrine of precedent, or developed based on the doctrine of precedent. And I already explained to you about the doctrine of precedent, which is applies in the common law country system. Case law, synonyms of case law is common law. They also mention it as common law. Also, they refer to as church make law. Okay, and in common law legal system, we also have statutory law. What statutory law mean? Anyone have an idea of statutory law? Statutory law mean written law. It also mean statute. It means legislation. It means acts of parliament. In the common law countries, nowadays, in common law countries, they have the parliament. Okay, you know parliament? Parliaments mean the legislator. Okay, would have a function to make law. Okay, and they actually have a main function to make law to govern the countries. And almost every common law countries nowadays have statutory law because they have parliament. In the past, they apply case law, and in the past, case law is the sole sources of law, okay? But nowadays, not only case law, but statutory laws will also apply, okay? And of course, there are some other sources of law in the common law legal systems as well, but we just focus on the two main sources of law. So I may make it here, main sources of law. And I have a question for you that if there is any inconsistency between case law and statutory law, which one will prevail? What do you think? Which one will apply? If there is any inconsistent between case law and statutory law, which one will apply? Okay, you may not know yet, right? So if there is any inconsistency between case law and statutory law, of course statutory law will apply, because you know that statutory law in common law countries always go after case law, because the original sources of law in common law countries was case law. Nowadays, because the parliament main functions is to make law, and because case law or just make laws are difficult to apply, because when you need to find the legal rules from case law, you may need to look at the whole case report. And the case report, it depends, but it can be 100 pages. And this is very difficult for you as a normal person to find out the main legal for the decision, the main reason for the decisions in the case law, in the case report. Okay, you need to find the main reason for the decisions, or in other words, it called stare decisions, in order to know what are the legal rules which can be binding on the later courts. So it's very complicated. So that's why the legislator, the parliament, codify the common law principle. They are professional. They look at case law reports. They look at the principle of case law of common law in order to codify them, to make them become statutes. And also with the developments of the society, many new things arise. So the parliaments actually adopt new law to govern the new matters. The new matters arise from life, from the society, and the parliaments will adopt law in order to govern those new matters as well. So therefore, statutory law come later. So, and they are in a concise format. They have a provision, they have a piece of legislation in which there are provisions, and its provisions have very clear about the scope of applications, about the regulations, about the rules, and about the relief for those who have been infringed of their legal rights and entitlement, or punishment to those who actually violate or breach the law. So if there is any inconsistency between statutory law and common law, statutory law will prevail. Okay? All right, so that is about the common law system with respect to the main sources of law. In civil law legal system, the first ever piece of law in the common civil law legal system is the civil code. That's why civil law legal system have its name like civil law, okay? Because the first ever piece of legislation available in civil law country is the civil code. and it's written on rock. Okay, so the main sources of law in civil law legal system and the original sources of law in civil law legal system is statutory law. Okay, that is the main sources of law, okay, in civil law legal system. But I have a question for you, that in the civil law legal system, whether they also use case law, in civil law legal system, whether they also use case law.
Yes. In
Yes.
civil law system,
All
they also
right.
use case law.
Good, good. So now I just want to ask about Vietnamese legal system only. Vietnamese legal system belong to civil law legal system, right? And in Vietnam, we apply case law officially from the Civil Proceeding Code 2015, right? So I have a question. That whether the doctrine of precedent as applies in common law legal system also apply in Vietnam with respect to case law, or to put it simpler, how case law is created in Vietnam? How case law is created in Vietnam? How case law is created in Vietnam? Is it similar to the creations of case law in common law legal system? Anyone know? In Vietnam, case law is created by the declaration of the Justice Panel of the Supreme Court. Case law of precedent is created by the declaration of the Justice Panel of the Supreme Court. You know what Justice Panel of the Supreme Court mean in Vietnamese? You know, in Vietnamese, Justice Panel of the Supreme Court means Hội đồng thẩm phán Tòa án Nhân dân tối cao. Okay, so you see the two ways of creating case law in common law legal system and in Vietnam. Can you point out the differences? Can you point out the differences? Anyone have an idea? Please feel free to raise your voice, please.
In my opinion, I think the difference here is that in common law system, case law doesn't have to be picked from any court, but just need to be effective after the judge declaration in one specific case, and then the case afterwards from lower courts can use that judgment. But in civil law system, the justice panel of the Supreme Court will select one of the decision or judgment from one effective judgment, and then they will put them into case law. So I think that's the biggest difference.
Right. So case law created in the common law legal system naturally and automatically based on the doctrine of precedent. Okay? Because it requires lower court to follow the decisions of a higher court in the same hierarchy if the facts are similar or identical. So it applies naturally and automatically based on that doctrines. But in Vietnam, with decisions of the church with decisions of the court will become case law based on the decisions made by the justice panels of the Supreme Court. Okay, they have a panel, they discuss to choose whatsoever decisions already been made by whatsoever court. If they think that decisions, that judgments is valuable in order to be learned, in order to be applied by any other courts in Vietnam. And then the justice panels of the Supreme Court will declare that is case law. That is the precedent, okay? And usually the precedents will be used in order to apply to the situations in which written law is silent or written laws is not very clear, not comprehensive about that particular point. So therefore, case law will apply in order to resolve that problem. Okay, so you can see that in the US or in common law legal system, lower court have to follow the decisions of a higher court. Okay, if the facts are similar or identical. So therefore, lower courts have no choice. They need to apply the decisions of a higher court if the facts are similar or identical. But the court itself will not be bound by its previous decisions according to the doctrine of precedent, and also the higher court will not have to follow the decisions of the lower courts, even the facts are similar or identical. But in Vietnam, when the case already been declared by the justice panels of the Supreme Court, and it's binding on every court in Vietnam, regardless of whether it's originate from a lower court, doesn't matter, okay? Even though it's come from the district courts, at the first instance, it originates from the district courts, okay? But when it is declared by the justice panels of the Supreme Court, it becomes a case law, it's become a precedent, and it's binding on every court in Vietnam, including provincial courts as well, and even the appeal courts of the Supreme Court. Okay, so you can see that So that is the key differences between the terms case law when you use it under a civil law legal system context, and when you use in Vietnam, it totally have different meaning. in fact, and also case law in the United States refer to the whole judgment, and the court will look at the judgment. The court will find out what is the stare decisis, which means that what is the key reason for the decisions in order to apply to their case. But in Vietnam, they just tend to be easier to apply case law, because when the justice panels of the Supreme Court actually declare that that particular case is the case law precedent, and they already make it very concise. Okay, just one paragraph, two paragraph, just the points that the justice panels of the Supreme Court want to be binding on every other courts. I can show you an example of the precedent under Vietnamese law. You can see over here. I will show you the example. I just pick one. You can see a precedent or case law can available in a particular website or the database like Thư viện Pháp luật. So you can see here that is the precedent numbers, etc. And it is declared by the decisions of actually the Chief Justice, but after the decisions, after the meeting of the justice panels of the Supreme Court. And you can see here. Okay, so there is some problems that I need to. Problem with the, just for a second. Yeah. So you can see here. You can see the president had been approved by the justice panels of the Supreme Court and had been declared by the Chief Justice of the Supreme Court. And they actually talk about the origins of the president. And they actually put it very concise. Okay, this is, yeah, they refer to the case, but just for reference, the case had been referred to for president only, but you can see here, the president is very much concise. This is in italic here, you see, the contents of the president, very much concise. Just half of the page. Okay? Understand about how presidents is made in Vietnam? So you see you see the differences, right? Okay, very good. All right, so we continue to look at the differences, okay. The next differences that I just want to point it out to you is that about the differences with respect to the applications of law. would actually mean the base or the ways the law will apply, or the system of the ways that the courts enforce the law. And in common law legal system, they use the doctrine or the principle with equal adversary system of trial. Okay, what does it mean by adversary system of trial? Adversary system of trial means that the trial means the court hearing, okay? And the court hearing is actually adversary, adversary adversary system of trial. What does it mean? This means that the court case, the court hearing, it's just like a battle. Okay, what does it mean? The battle means like the two parties fight against each other. Okay, and in that system of trial, the parties have an obligation to present their case. Okay, so they are under obligation to submit the case. Okay, and when they have an obligation to submit the case, they have to submit evidence. Okay, and they use evidence as a weapon to fight against each other. The role of the church is rather inactive. Okay, the church just listen to the party argument. Okay, and to conclude the case based on the evidence submitted by the parties. So that's why the case hearing in the common law legal systems is very much lengthy. It's long. Okay. All right. But in Vietnamese legal system, we used the system with equals inquisitorial system of trial. So in the inquisitorial system of trial, the church plays a more active role. The church keeps asking questions in order to find out the truth. Okay, the courts play more active role. Okay, so that is also the differences. Okay, between the two legal systems. Why I actually want to tell you at the very beginning about the differences between the two legal systems, because later on when we study about tort law, we will compare and contrast. And when we compare and contrast, we should bear in mind that the two legal systems have some differences. So because they have some differences, we may not be able to apply the rules in the US into Vietnam in its entirety. You may need to use it. You may need to learn it and apply it, given the facts that each country have different legal system. Okay, in common law legal system, church can make law. Okay, church can make law. And where there is no written law, church can create law. Okay, very naturally. So for that reason, written law may be very general. Written law just adopt general rules, principles. And when applied general rules and principles in realities, the church will take into account the circumstances of the case, the facts of the case, to judge the problem. Because the church in common law countries seem to have more power than the church in Vietnam or in civil law countries generally. Because in civil law countries, we base our system on written law, mainly on written law. Okay, case laws are being used, but within a very limited manner. Okay, so for that reason, the law needs to be more details. The law needs to be more details. So you have to bear that in mind when you criticize about the law of the two countries. You should not have the view, or you should have an opinion. You should not have an opinion or the views that US law is very good, US law is very comprehensive. Why we do not apply the same thing in Vietnam? Impossible. Okay, because different countries have different backgrounds, different countries belong to different legal system with different characteristics. Okay, if we want to improve the legal system, we have to improve everything at once. Okay, so if we can't do it at once, we need to do step by step. And when we do step by step, we need to do it little by little. Okay, and we have to consider whether they are actually relevant or whether they are actually suitable. Okay, given the facts of the level of developments, given the facts of the cultures of the countries, given the facts of the characteristics of the legal system, the origins of the legal systems, etc. Okay, do you see my point? Any questions so far? Okay, clear? So can I move on? Okay, good. So here is the slide on the assignment, grading weight, text and required rating. I already show you the required ratings and I will probably send around more material for you because you study online. We do not have a chance to see each other in person so that I can give you a hard copy for copying. So I will send some more materials via email, okay? Maybe to the group leaders or probably to the group, the class monitor, and ask her to circulate to you. Okay, so for the assignments, okay, we will have the project work and presentation, and that occupies 30% of the total mark, and the final exam will be 70%. For the project work and presentation, we have 30%. And for that part, I will send around the problems to each of the groups. And I just want to tell you about this right now, that maybe I will divide you into groups of 3. Maybe the group of 3 because your class members, your the number of the students in your class is quite small, but I will divide you into a group of 3. Maybe it depends on the final number, but maybe some group will have 4. So we may have 6 groups only, okay? And I will allocate the time for the group to make presentations as well, usually at the end of the course schedules. And for each of the groups, I will send the problem-solving questions to the group leader email address. And each of the groups will nominate a group leader, and the group leader responsibilities is to organize for the preparations and presentations of your presentation. And for such arrangement, the group leader will be given 0.5 bonus for his or her effort to organize everything. Okay, and remember that everyone have to participate in the preparations of your presentation. And on the days of your presentation, you need to submit to me before the days of your presentations, just 1 day before. You need to submit it to me. You need to submit to me the presentation, your presentation, PowerPoint slides. Okay, if you want to submit also the work files, it's okay, but it's a must that you need to submit to me the PowerPoint slide. And my requirements for PowerPoint slides, that for the first slides, you have to name your group, for example, group 1, okay? And you list all of the group members with the ID number. And also you should give a remark to the group leader. Who is the group leader? That is for the first slide. For the second slide, please, I need to emphasize that for the second slide, you need to paste the whole problem-solving questions that I send you. Okay, the whole thing. Do not summarize in the second slide. In the second slide, you have to put the whole thing. The reasons that I want you to put the whole things on the second slide is that when you present, you are able to show that slides to everyone. And I don't want you to show the summaries only. You can summarize, but you summarize later after the full problem-solving questions. The reasons is that because when you summarize the case, you may omit some facts, some important facts. So that's why I just want you to have the entire problem-solving questions that I send you in your hand available in order for you to solve when I ask you to do so. So therefore, if your your questions is too long, you can't put it on one slide, you can break it into 2 slides. And you should also prepare the work file as well, which contains 1 page. And that page contains the full problem-solving questions that I sent to you. Okay? And from the third slide, you can do whatsoever you want. Okay? You can do whatsoever you want in the third slide onward. But for the first 2 slides, please follow my instruction. Okay, is it clear? Anyone have any questions?
Miss, I do have a question.
Okay, yep, sure.
It is related to the member of the group of the presentation. So you're going to divide us into smaller groups, or we can do it ourselves?
I will do that. I will do that. The reason, I will explain to you a reason why I want to allocate the group members. The reasons is that because I want you to work with different people. I don't want you to work with your close friends. Okay, I don't want you to work with the same person, the same people for many subjects. Okay, so you learn the soft skills when you work with different people, different person with different personalities. Okay, so I want to actually to give you an opportunities to exercise, okay? Working in group skills. In the futures, you can work in group with people you don't like, person you don't like, you do not know very well, you don't like, you are not close friends with, etc. But you need to do so in real life. So therefore, I want you to learn some skills, working in groups, working with different persons, okay, how to cooperate with others, how to get along well with different person. So I will do that. Okay.
Okay, I understand.
Yep. Okay, good. Okay. Any other questions for the representations? Okay. Okay, the text and required things I already showed you, and you also have it in a e-learning website, on e-learning websites. Okay. The teaching methods. Okay, with respect to the teaching methods, of course, lecturing is a must because I need to explain to you first of all. Okay, and then case study, you have a chance to do a lot of case study. Not only for the SIG group presentations, because the SIG group presentations, we have 6 problem solving questions only, but in the guidance question, you can see at least we have 10 problem solving questions. Some of the problem solving questions in the list, in the guidance questions will be sent to you at group presentations, but some of them still need to discuss. So therefore, we will have tutorial sections in which we will discuss the cases, okay? All right, working in groups, as I already mentioned, you will be divided into groups and you need to work with each other, okay? In a COVID pandemic, you may not be able to see each other in person, but thanks for the developments of information technologies, you can work with each other very well by using many means of communications, including Zoom, including Google Classroom. You can see each other, you can work with each other through those mechanisms, technique. You have Viber groups, Yellow groups, Facebook, okay? Lots of you using Facebook. You can communicate with each other. You can make telephone call free of charge. You only need internet connections, okay? Right, so you can work in groups very easily, discuss with each other if you can't gather in person. I think that the group of 3 can gather in person, okay? But if you are in different places, it seems to be impossible for you to do so. And in order to be safe, okay, you can work online with each other. And playing roles, how playing roles work in our course. Actually, when you make a presentation, you can play role. In the previous course, I have a class that a student in the class, actually, when they present their problems, they actually play roles, okay? Like they make a courtroom, or they may do in the format of the lawyer and client, who a lawyer give advice to the clients and people play role at the lawyers, at the clients, okay? And some groups is actually do videos of the facts of the case. They play roles in a video. But if you make a videos, you only make a videos of the facts of the case. For the applications, for the resolving the case, you need to do it in person online, okay? Which means that when your group make a presentations, each of the members of the group need to present in front of the class using Zooms, okay? We have techniques in Zoom class, in virtual classrooms, in order for you to present your case. Okay. Remember that every members of the group need to present in your presentation's date. Okay, I will actually put the agenda or schedules for your presentation. Okay. After I have the list from Nga, I will divide you into groups. Okay, send it back to Nga, and she will help me to work with you in order for the group to appoint the group leader and put the group leader email address back to the list, or maybe we will do it in the class by using chat box. Okay, or yeah, you can just put it other in order to nominate the group leader. And remember that the group leaders have some responsibilities, and in consideration for the responsibilities, they will have 0.5 marks. And also remember that in the class, during the class time, you can participate in the class discussion, raise the questions, answer the questions raised by me. Okay, and then by doing so, you will be given bonus as well. Okay. All right. Any questions so far? No? If not, we move on. Here is the contents of our code. Okay. We have 5 chapters. The first chapter is Introduction to Tort Law. The second chapter, Intentional Tort. And for the second, the third, and the fourth chapters, we only look at US law. They are types, the main types of torts under US law: intentional tort, negligence, and strict liabilities. Okay. Chapter 5, okay, we look at special types of tort under Vietnam Civil Code 2015. Okay. Now we look at the first chapter, Introduction to Tort Law. We have several subtopics. Okay. Introductory concepts, sources of law, the basic natures of tort, difference among torts, contracts, and criminal laws, remedies available under tort law, categories of tort. Okay. For the first chapter, we will look at US law and Vietnamese law at the same time, which means that we will more focus on US law, but we will compare the general concepts between US law and Vietnamese law as well. Differ from the next 3 chapters. We only focus on US law for the next 3 chapters, but for the first chapters, we will compare and contrast. And the last chapters, we will look at Vietnamese law. And in the last chapters, we will have the chance to compare and contrast with US law as well, after you already learn US law. Okay? So, what the tort means? Tort is actually a French word, which means a wrong. A wrong. So when you do something wrong, you commit a tort. When you do something wrong. Okay? So what the wrong mean? Wrong can be an act or an omission to act. Okay? And the wrong which is subject to tort law is a legal wrong. Legal wrong means that what you do is not allowed by the law, or you do not do something that the law requires you to do. So that is a legal wrong. Okay. All right. So remember that a wrong can be an act or an omission to act. Sometimes you do nothing, but you commit a tort. Okay. So anyone can give me an example of a situation in which you commit a wrong by doing an act. An example of the situation in which you commit a wrong by not doing something. A wrong can be an act or an omission to act. So anyone can give me an example of a wrong in the forms of an act, and a wrongs which is in the forms of omission to act. Anyone can give me an example?
Yes, I would love to give the example of a wrong as an act is that when you intentionally hit someone and hurt that person.
Okay, all right. Yes, that can be an intentional tort. Good. When you hit someone, yeah.
Yes, and a wrong as an omission to act is that when there is a failure to pay tax.
Okay. All right, thank you. Anyone else have any other example, especially for the example with respect to omission to act? And you can also have a comment on Châu Long example. Anyone else want to have other examples? Châu Long have an example with respect to an act which is an intentional act, whether sometimes you did not intend to do something, but you also commit a wrong. Anyone can give me an example of unintentional wrong as well, and also the example of inaction or omission to act which results in a wrong. Okay, I think that maybe we do not have much time, so I just want to give you example, and you can think of more example later on. So for unintentional wrong, is the typical example is a vehicle accident. Okay, accident happened, you did not intend, but you caused someone injury, you did the wrong thing, and you commit a tort. For omission to act, your friends already gave an example of avoiding paying tax, but in fact, if you avoid paying tax, and you will be subject to administrative law, so that is actually an administrative wrong. Is not covered by tort law in a normal sense, but it is subject to administrative law. But for the example of omission to commit a wrongful act, which is subject to tort law, can be like, for example, the office building who run the office, but who did not maintain the elevator or the lift as the law requires. So something happened with the lift, okay, and that cause injury to someone, okay, and in that situation, by inaction, which means that the building operator did not maintain the lift system, right, or the elevator system. So non-actions of the building operators cause injury to someone, and the building operator will be responsible under tort law as well. Of course, he may also be liable under criminal law, but criminal law is something else. We will compare criminal law and tort law, or criminal law and civil law, because tort law belong to civil law. We will talk about differences between civil law and tort law later on. Civil law and criminal law later on. Okay. All right. Okay. So I think that we can stop here for now for these sections, and see you next sections. Okay.
Okay.
Thank you, everyone. Okay. Bye-bye. Okay. I will send the list of the student that I have to Nga. Okay. And she will help me to put the names out, to remove the name with